Warren Buffett says you should share the terms of your will with your children. But if you're not ultra rich like Warren, does that mean you should also be doing it? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota, and New York City. And today, let's look at some advice from Warren Buffett last week, sent out to his shareholders about the importance of speaking to your family as part of your estate planning. Warren's message to his shareholders was that you should share your will before it's too late. Now, in his situation, he's a billionaire who's 94 years old, and he is trying to explain to people that avoiding this family drama is not just for the ultra rich. In fact, he encourages you to discuss your will with your children before you even sign it. His idea is that the transparency now will save the heartbreak later. So, in Buffett's world, he has a simple strategy for addressing this with your children. First, if you have mature children, make sure they read your will. The second step would be to explain your decisions and their future roles. So some roles that you may find under a will or under a trust will be a personal representative or an executor, which is somebody who will be in charge of your estate after you're gone. If you have a trust, then some of the roles we're looking at are a trustee, who'll be the one, once again, to manage the assets in the trust. And also in a trust, you have beneficiaries, who are the people who will be receiving money under the trust. And the third part of Warren's strategy is make sure you're going to prevent the why questions after you're gone. So in his strategy, what we're doing is telling the children or the other family members why you're doing what you're doing with your estate plan so that nobody has to ask, why did he do it after he's gone? It probably will not surprise you that estate planning lawyers like myself often agree that discussing it now can be a great idea. As Warren points to, we can minimize conflicts amongst your family members. So if everybody knows that this is going to be what's happening with your will, here's what the distribution is, then it's going to minimize that conflict after you're gone. Second, it's going to clarify your intent. So your children may not understand why you're doing a specific distribution or a specific setup under your will. And so if you have this discussion with them now, you can explain what your intention is by creating these documents. And the third thing that may or may not actually happen in your family is it may actually strengthen your family ties, meaning that you can have this discussion, the family can feel involved in the estate planning process so that nobody is left out in the dark and finds out later that they are not receiving an inheritance or are receiving less than they thought they were going to get. So especially if you're going to be leaving an uneven inheritance, let's say you have 3 children and you're not going to split it 1/3 each, by making sure to discuss it with them ahead of time, nobody is surprised when they see your will and find out that one sibling gets 20%, the other 2 get 40%. There could be a variety of reasons why you would want to have an unequal inheritance. And again, it's your choice. It's your estate. You can leave it how you would like. But by explaining that to your children, it may provide them with some clarity and they won't feel as put out when they find out that it's not a straight equal distribution. What I saw when I was looking at some surveys online is that actually 35% of families don't actually plan to discuss their inheritance with their family members, meaning you're leaving 35% of the population who have a will, and frankly, only about 1/3 of the population even has a will. So we're looking at a very small set of families who are having these discussions. And of those 35% of families who aren't planning to discuss the inheritance, there's actually only 25% of people who've even had that talk. So we're looking at a very small subset of the families out there dealing with their estate plan and making sure to have this discussion. If you're going to ask an estate planning attorney what the best practice would be on this, it would be to start small, do it early, and do it often. So what this does is that will reduce the stress around your estate plan. You can have little discussions with your family over the years. It doesn't have to be setting down a 85-page trust in front of them and saying, I signed this last week. Here's what's going to happen. You can have discussions throughout the years. Let's say we have one sibling who is financially very wealthy, really won't need money, and is really more interested in some family heirlooms. So we may actually skew our estate so that they're getting more of these personal items, while their siblings who could really use the extra money are actually getting more money. Those heirlooms aren't worth as much monetarily, but they are traditional gifts that you would give to them, and they have sentimental value, and that's what they really want. So going back to Warren Buffett and his strategy, at this point, his children actually oversee his $150 billion fortune. And what he has done is he's shared his values, and openness with them has created this successful plan. So he has brought his family into the mix. And again, these are mature children. So he's 94, his children are much older. So if you have a 10-year-old and you have a 12-year-old, this is not the process for you. You're not going to have that discussion with them. In fact, the discussion you're going to have is with whoever would be their guardian and who would be the trustee to manage their money for them. But if you have mature children like Warren Buffett, you can use this situation to have these discussions and actually bring them into the process. What we don't want to do is keep everything totally secret. And the reason is, if you pass away tomorrow and your family inherits a bunch of money, they may not have been intending to do that. With the new Secure Act provisions requiring you to take distributions of retirement accounts over a 10-year period, this can have a significant effect on your children's tax bracket, whether it goes to your spouse or whether your children. There's different provisions under law. But by having that discussion ahead of time, your children can also start preparing for what that tax impact would be, because otherwise they might just blindly get this information after you're gone. They didn't know they were inheriting all this money, and now they're getting knocked up another tax bracket or two, and they have a big tax bill due that next April. So let's look at a 3-step action plan that you and your family can take. Number 1, summarize your will for your family. If you don't know how to summarize it, ask your estate planning attorney. They can often actually give you a document that is going to be a summary of your will. Number 2, have a meeting with your lawyer. So if you're really not sure how to explain it to your children or your family, set up a meeting with your lawyer and your family so that everybody can sit around that table and get the information they need. And number 3, follow up with each family member individually to make sure they understand what's in the estate plan and what's going to be left to them. So if you have more questions you'd like to discuss creating an estate plan for you and your family, you can go to my website, andrewmayers.com. There's a red legal strategy session button at the top of the page. If you click that, you'll be taken to my personal calendar. We can set up a free 15 or 20-minute phone call, a legal strategy session to discuss your estate plan and where you are in the process. If you like this video, you can hit the like or thumbs up button below. You can go over to YouTube or ayerslawtv.com and subscribe to future episodes. And remember, Warren Buffett's advice doesn't just apply to the ultra rich, it applies to anybody with family. We want to make sure we have that transparency so that your family is involved in the planning process and that you can truly leave your legacy in the way that you intended and not leave behind a fight in probate court because someone's feelings are hurt when they're not receiving an equal inheritance to somebody else.